all the participants also. A very good morning to all of you. Hope you all are doing good. Uh, See, this topic which we have is based on the asset reconstruction companies and what is the interplay of this asset reconstruction companies with IBC. So, as we know that ARCs were formed under Sarfazi Act, and quite a good role they are been playing, and since a long time they have been working. But how we can, use that structure in IBC and can take benefit out of it. So that is what we will be doing in this session. That is what we will be searching out in this session. More or less, the things, the complications of the law, they are still the same. Um, at some point of time, there is some clarity in some of the cases. We will be studying those cases as well. So what I have done is I have divided my session into three parts. The first part we will be taking up regarding the legal provisions for this ARC. How is it different working in both the scenarios? Like if ARC is working in Sarfazi, how it works there. If it works in IBC, what is the benefit or what is the role there? So the different roles we will be seeing, and then what is the current any guidelines or any circulars issued by RBI which is facilitating this structure in the IBC, that also we will see. So that is the first part, the legal provisions and all. And then the second part we will see what are the challenges faced by IPs while working with ARCs. So the challenge part and how to resolve these challenges and what steps we can take or what precautions we can take so that the whole process becomes very smooth. That will be the second part. The third part, we will take up some FAQs and simultaneously we will be discussing some case laws. So that is how the whole structure is being planned. So I'll just share my PPT. Let me know if that is visible. Is my PPT visible?
No.
All right, maybe it is visible now.
Now visible, now visible, now visible.
Okay. Thank you so much. I'll just make it full screen. Yeah, so the topic for the day is impact of IBC on ARCs, that is asset reconstruction companies, and the debt restructuring part. So as we all understand that ARCs operations, they enhance the efficiency in acquiring the distressed assets. And with respect to the corporate debt restructuring, it provides a very transparent mechanism for restructuring. It is obviously a lender for the recovery mechanism. It streamlines the whole recovery process for the lenders. So normally, as we see ARCs, what they were supposed to do, they used to take the NPAs from the bank in their account, and then they formalize the whole structure with respect to the recovery process. So to fasten the recovery, all that procedure is being done by ARCs in the SARFACI that we have already seen. Now, talking about their economic stability and the overall stability in the Indian scenario, ARCs obviously contribute a lot to the stability and growth of the economy because where it was impossible for the banks to recover, there it was a need to have a separate set of organization wherein the recovery process could be enhanced. So there were three mechanisms, not just one. The recovery, it was revival, rehabilitation, and passing the recovery process. So that was the overall structure with which the ARCs were formed. So let us understand the concept under the Sarfazi Act 2002. that is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, which is the foundational statute under which this ARCs were established, and they are being still regulated under that. So anyone who wants to form an ARC, they still have to go to SARFAESI Act. They still have to follow the RBI guidelines, and then thereby they can constitute this structure, and then proceeding the provisions which are given there, they can take up wherever they want, either in the IBC scenario they can come into picture, or in the SARFAESI itself they can start the recovery proceedings. But the whole setup is given in SARFAESI only, how this ARC will be constituted. So let us understand the legal provisions. Section 2(1)(b), it contains the definition of the asset reconstruction company. Asset reconstruction company means a company registered under the company registered with the Reserve Bank of India under Section 3 for the purposes of carrying on the business of asset reconstruction and securitization both. So here, if you can see that it should be registered with RBI for the purpose of carrying on business of asset reconstruction or securitization. So is there any difference between asset reconstruction or securitization, or what is it? So all these definitions are given in SARFAESI itself, but the ultimate thing which we should understand is this asset reconstruction company has to follow the provisions given in SARFAESI, as well as they have to abide by the guidelines given by the RBI from time to time. An ARC must be a company registered under the Companies Act and must obtain registration from the RBI under Section 3 of the SARFAESI Act. So this is the overall structure which we should understand. This is practically speaking a company registered under the Companies Act, and they must obtain registration from the RBI as well to function as such under the Section 3 of SARFAESI Act. Section 2(1)(za) tells us the definition of securitization, because this is one word which will be used a lot of times in the whole act and at various scenarios also. We all understand what is the meaning, but quickly let us just refresh our knowledge. Securitization means acquisition of financial assets by any securitization company or restructuring company from any originator that includes the raising of funds by such company from qualified buyers by issue of security receipts representing such financial assets. So normally what used to happen, or what actually happens in the SARFAESI scenario at present, the ARCs, the asset reconstruction company, what they do is they take up the NPAs of the bank, and in lieu of that, they give them the securities. Right here, it is mentioned security receipts representing the value of those financial assets. So maybe they are taking up the NPA of 200 crores, let's say, and they are discounting it on their part, and then they are issuing the security receipts of, say, 100 crores to them. So banks will be under the impression that they are now not they are out of the burden to seek the recovery. That whole part will be taken up by the asset reconstruction company, and they would on their own make efforts for the recovery process. And this is how it is dealt in their balance sheet. So this security receipts is basically how is it displayed on the balance sheet side. So if asset construction company has taken up this NPA and it has issued the security receipts, the security receipts will form as an asset in the books of the banks. So that is how it goes. Moving further, Section 2(1)(5), it talks about the definition of the financial asset, because once it is financial asset, that is only taken up by the asset reconstruction company. So financial asset here means the debt or the receivables, and also includes a claim to any debt, whether secured or unsecured. So irrespective of the fact whether it is secured or unsecured, they can take that up. Second, any right or interest in the security, any beneficial interest in the property, or any financial assistance. So in whatever name it is given, that can be taken up in the name of the financial asset altogether by the ARC. So this allows ARC to acquire both secured as well as unsecured loans from the banks as well as the financial institutions. So normally we should understand that it is not just the matter of the secured part, but also the unsecured part can also be taken up by them. So in the case of SR Steel India Limited, that was a Supreme Court decisions. I think this is not relevant at this part. We will take up the cases later on. So registration and creation of ARC, how is it dealt in section 3? Because the section 3 was referred here. So section 3 talks about the requirement of the RBI registration, which we should understand at this point of time. So section 3(1) talks about the requirement of RBI registration, because until and unless these ARCs are registered under RBI, they cannot function as such. So no securitization company or restructuring company shall commence or carry on the business of securitization or asset reconstruction without obtaining a certificate of registration granted by the Reserve Bank of India. And so there is one more allied condition. So both of these conditions have to be satisfied. They have to obtain a certificate of registration granted by RBI, and at the same time they should have a net own fund of not less than 202 crores. So this was the initial amount which was quoted. However, this has been changed now. RBI has increased this minimum net own fund limit requirement several times, and the recent amendment was made in 2024, wherein they have prescribed the minimum net own fund should be 300 crores, and this was done by a RBI Master Direction 2022, and this has been further updated in the later years also. So till 2026, I mean 31st March 2026, any of the these ARCs which are functioning, they have to maintain the net own fund with a minimum balance of this 300 crore net own fund of 300 crore. So at this point of time, let me just ask, can ARC with this minimum requirement of 300 crore, can it participate in the IBC process, or is there any other requirement with respect to that? Is there any limit of the net own funds with which the ARCs can participate as a resolution applicant in the IBC process or CIRP process as such? Anyone has any idea? You can just unmute yourself and you can speak up. Or you may even put that in the chat box also if you want. I'll repeat the question. Is there any threshold limit for this ARCs to participate as a resolution applicant in the CIRP process? Well, there is a limit. It is, okay, I think I have one answer. Okay, it's just the participants are mentioning their names. So,
Normally, madam, I'm Sudarshan
yes,
here. Normally,
yes.
we set that eligibility criteria in our document. If that eligibility criteria satisfies, we are okay with that. I don't think that we look into these aspects. What we set in the eligibility criteria is that the minimum net worth available and whatever that, we set some requirements. If they meet that criteria, I think we'll go ahead with that. This part, I am not aware of any.
There is some criteria, and that is why I'm asking. So normally
Okay,
we do not
okay.
check that. So
Okay.
at the time of doing that CIRP process, we check the eligibility criteria which is mentioned in 29A. So the people who are not disqualified as per 29A, we allow them as this prospective resolution applicants. So if this ARC also wants to become the resolution applicant, it has to fulfill the criteria which is given there. But there is a specific guideline for the ARCs. So that is what I'm asking. There, the net own fund is 1,000 crores. So though they can start up their functioning with 300 crores, however, only if they have 1,000 crores as the net own fund, then only they can participate as a resolution applicant in the CIRP process. We will discuss that as well in the later part of my slides, but I just wanted to have it here also, so that this will be emphasized, and this is something which we must remember while studying this ARC topic. That is very, very important. Let us go further. Section 3.2. So what we are doing right now is we are studying the provisions as per SARFAESI only. So regarding the formation of ARC, what are the applicable provisions in the SARFAESI along with RBI guidelines? That is what we are studying, because we must first understand the concept of this ARC altogether and how it is governed by various legal provisions. We must understand that, and then we will correlate it with the IBC provisions. So section 3.2, it talks about the application to RBI, because just now we read that there were two conditions. First condition was to obtain a certificate of registration from the Reserve Bank. So anyone who wants to, work as asset reconstruction company, they have to obtain a certificate. First, they have to establish a company. Then they have to obtain a certificate also from the Reserve Bank of India, and they must have a minimum threshold, that is net own fund of minimum this 300 crore. Then only they can work as asset reconstruction company under SARFAESI. So how to apply to RBI for the certificate? That is what is given in section 3.2. So every securitization company or restructuring company shall make an application for registration to the Reserve Bank in such form and manner as may be specified. So the particular formats are given. Section 3.3, it talks about the RBI scrutiny. So as and when an application reaches to RBI, they do a proper checking, they do a due diligence, they do a proper scrutiny whether this particular company is fit to be given that certificate to work as an asset reconstruction company under SARFAESI. So the RBI may, for granting registration, inspect the records or books of the applicant company to satisfy itself about the financial soundness, management, and compliance with the guidelines. Moving further, section 3.4. So once RBI is satisfied, they have already scrutinized everything, then they may give the certificate of registration to them. So RBI, after being satisfied, may grant a certificate of registration to carry on the business of securitization or asset reconstruction or both. So see here, they have made a distinction, if you can clearly see. They can even either give the certificate to carry on business for securitization or asset reconstruction or both. So likewise, we should understand there is a distinction between these terminologies which are used. Next, section 3.5, it also gives the power to RBI to cancel the registration at any point of time. So RBI may cancel the certificate if the company ceases to carry on the business or fails to comply with the conditions. So this is very, very important, that whatever conditions are, or the circulars or the guidelines which are issued by RBI from time to time, ARC has to fulfill those. And if they are not fulfilling those, then at any point of time, RBI can cancel the certificate. So legally speaking, they will not be considered as ARC from that point of time when their certificate is cancelled. So whenever there is an ARC in front of, when we are working as IPs, we must understand whether there is any non-compliance on their part for the RBI regulations. So if that has happened, it may be possible that their certificate will be cancelled in near future. Let us understand the business operations of ARC, which is given in section 9. So section 9 talks about the measures for asset reconstruction. So an ARC may, for the purpose of asset reconstruction, adopt any of the following measures. So this is all the scope of work which ARC can do. And this is given in section 9 of SARFAESI Act. So why we are studying this again and again? Because this is the starting point which tells them that now you can, even go in IBC and take up the role as a resolution applicant and work accordingly. So if that part is not given here, they cannot go ahead and do those kind of activities in IBC. So let us understand what is mentioned here. First thing is they have to, first thing which is mentioned here is proper management of the business of the borrower, because they are taking the NP accounts from the borrower. So that is what they have to from the banks they have taken up, and the assets which have come into their control, they have to manage them properly. They have to properly conduct the business of the borrower. They can even conduct the sale or lease of the part or whole of the business. Then C is the rescheduling of the debt repayment. Fourth is the enforcement of the security interest. Next is settlement of the dues. And the last is conversion of debt into the equity ownership. So here you can see these are the six functions which they can uh, delve into, or they can actually do these functions. So these are the statutory tools which are given to ARCs to restructure or recover NPAs. So that is how they go for it. Either they go for sale, or they can even try and do rescheduling for the debt payments. They can even enforce the security interest. They can even go for the settlement of dues. Normally, in normal scenarios, the C, D, and E are mostly in the common things which are seen. So these three functions are mostly seen in case of asset reconstruction companies. Moving further, once an ARC acquires the financial asset, it can enforce security interest under Section 13(4), that is, take possession, manage, or sell the secured asset of the borrower without court intervention. So, this is very, very important. So, it has all the power to take the asset in its own custody, in its own possession, without taking any court approval for that. And this is mentioned here in section 13 itself, but it should be subject to the notice which is given under section 13(2). So this is the most powerful mechanism under SARFAESI that distinguishes ARC from the ordinary lenders. So if ARC has the control, then they can have the possession, they can manage, they can sell the secured asset of the borrower without the court intervention, and that is what the powers they have. Talking about the regulatory framework, there are some RBI master directions for them. RBI governing regulations for the ARCs. There is a proper RBI master direction for SARFAESI, which is given on October 11, 2022. And this is the circular number for that. What were the provisions here? So the key provisions include minimum net owned fund requirement should be 300 crores for any these asset reconstruction company. They should have a minimum requirement of net owned fund for 300 crores. They should have a fit and proper criteria for sponsors and directors. So all details are there in the circular. We, if time permits, we will take up that circular also so that we can see that. There is cap on the investment in the security receipts. Then governance and disclosure norms are also there. How they have to disclose a variety of things. So that is also there. Then there are various activities which are permitted as per this circular was asset reconstruction, securitization, acting as resolution applicant under IBC. So these are the two important takeaways from this master circular issued by RBI. One is that nowadays the net owned fund requirement for any of the asset reconstruction company is minimum 300 crores. So with that only they can start up their business, or even if they are existing, they have to reach to that threshold by 31st March 2026 if they want to continue their business. And the second most important thing is this circular has allowed ARCs to act as resolution applicant under IBC. So this is now in the permissible activities of ARC to act as a resolution applicant. So this is what we must understand at this point of time. Now let us understand the interaction of ARCs with IBC. How both of these laws should play together. So while SARFAESI is the primary enabling act for the creation of ARC, the Insolvency and Bankruptcy Code 2016 recognizes ARC as the financial creditors and potential resolution applicants. So here itself you can see there are two roles which can be played by ARC. One is they can become the financial creditors. At the same time, they can be the potential resolution applicants also. So how they can be a financial creditor? this question should come to your mind, whether they can, in the position of ARC itself, can they file Section 7 application? Yes, they can very well file Section 7 application because they have taken up the NPS from the banks, and now they are acting as an assignee. So assignee is as good as uh, that is as good as a person who can initiate the proceedings under the IBC, and they can file the application under Section 7 under the financial creditor category. So let us understand the provisions which are contained in IBC, which help ARC or which impose some impact or effect on the ARCs. So first and foremost is Section 5, Clause 7, which says that financial creditor includes a person to whom financial debt has been legally assigned or transferred. And therefore, ARC, that is Asset Reconstruction Company, becomes financial creditor once the debt is assigned to them. So as soon as the debt is assigned from banks to the ARCs or any other financial institution to ARC, they are in the position of assignee, and thereby, as per the provisions of Section 5(7), they come into the category of financial creditor, but because it includes a person to whom the financial debt has been legally assigned or transferred. Moving further, Section 5(8), it defines the financial debt. So any acquired debt continues to qualify under this definition. So even if it is not a primary debt in your name, still if it is, if you have acquired it from someone, it will still qualify to be called as a financial debt as per the definition. Next is Section 7. It says that financial creditor may initiate CIRP on default of rupees 1 crore or more, and therefore ARCs can also file Section 7 application against the corporate debtor if they are fulfilling this threshold limit of 1 crore default. Next, Section 21 regarding composition of committee of creditors. Here, it simply means that ARC also has the voting rights proportionate to its debt. So they can also, they will also be part of COC, and if they are not related, they will also have the, voting rights in the committee itself. So Section 29A, which talks about the ineligibility to be a resolution applicant. ARC must ensure no disqualification under this category. So indirectly, it is allowing you to become resolution applicant. So ARCs can become resolution applicant, but the underlying condition remains the same. They have to fulfill all the conditions which are mentioned in the Section 29A. That means they must not be the related party to any of the directors or corporate debtor, etc. Next is Section 30 and 31 regarding submission and approval of the resolution plan. So here ARC can submit or vote on the plan. So if they want, they can submit a resolution plan. In other role, they can be part of COC and they can vote for the plan also. So that is how it can work out. Next is Section 52 and 53, which talks about the rights of secured creditors in liquidation. ARC can enforce security or relinquish to liquidation asset. So these are also the rights given to ARC. They can enforce the security if they have any, because they can have secured loans or unsecured loans both. So if they have any security interest, they can enforce that, or if they want, they can relinquish it to the liquidation estate also. So these are the provisions which we must understand, which makes actually the ARC come into the picture of IBC. These all sections play a very important role. That is how they can get connected to IBC. And they can play the role of financial creditor. They can become part of COC. They can, even become a resolution applicant in any of the cases. So that is how it goes. Moving further, understanding the role of ARC, that is, we will now be distinguishing their role under the SARFACI versus IBC. So as we know, the idea is altogether different in SARFACI and IBC. In IBC, we talk about the maximization of the wealth, We talk about the resolution plans. We talk about the revival of the corporate debtor as such. So how these things take place, and who are the governing authorities for ARC in case of SARFACI and in case of IBC, how it's working is different altogether in these two scenarios. So there will be various parameters on which we will be discussing the role of ARC under these two headings, that is SARFACI and the IBC. So let me just go ahead. So here we can see on the extreme left side, I have put the aspects or the basis on which we will be discussing these two, his role in these two scenarios. So if we talk about ARCs under SARFACI, that was pre-IBC regime, or if they are still doing things under SARFACI, it will still continue to be in this category. And if ARCs are working under IBC, how will it go? So the enforcing agency or the enforcement authority will be SARFACI in this particular category. If they are working under SARFACI only, and if they are working under IBC, completely it will be taken up by the IBC provisions. What is the objective? The objective in both the cases is different. In SARFACI, it's basically the recovery and reconstruction of NPAs acquired from banks or FIs, while in case of IBC, resolution and revival of stressed corporate debt through a market-driven time-bound process. That is the whole thing, because here time limit is also there. In case of SARFACI, there was no time limit, but here in IBC, they have to adhere within and they have to work within the time limit. That is very, very important. Then next is the primary role. So here in SARFACI, ARCs act as a recovery agent. They purchase the NPAs, enforce the security, and realizes dues for the investors. While on the other hand, in IBC, they act as resolution applicant, or they act as a resolution participant or resolution applicant. So here they formulate and implement the resolution plans under CIRP or liquidation framework. Moving further, with respect to the mode of acquisition, in SARFACI, they acquire financial assets from banks or FIs through assignment under Section 5 of the SARFACI, while in case of IBC, they may acquire claims through CIRP process or as a resolution applicant, or through an AIF or SR trust investing in distressed asset. So this is how they may acquire the assets in this particular case of IBC. Moving further, regarding the control over the borrower. So in SARFACI, if we talk about the SARFACI regime, they gain rights over the security, and they may take possession, manage, or sell the secured assets, which is the powers which are given in Section 13(4) of the SARFACI. We have just seen that. However, the borrower company remains separate altogether. So they have all the rights over the property. They can have the possession, they can manage it, they can sell it without even having the court interference. While in the case of IBC, once CIRP begins, the company's management is suspended, a resolution professional takes over, and if ARC is a resolution applicant, it may take control post approval of the plan. So with respect to the control over the assets, so if ARC is filing in the position of financial creditor, if it is filing a Section 7 application, in that case, the complete management will be, company's management will be suspended, and even it will not have any role. In fact, IRP will be appointed, and that will take over the control. So resolution applicant or the IRP, resolution professional or the IRP, whoever will take the charge, and ARC will not have the charge as such. And if we talk about ARC in the position of resolution applicant, in that case, it will take charge or it will take the control post approval of the plan of the resolution plan by the NCLT. So before that, he does not have any control over the assets. Just it is the opposite, because in SARFACI it has the control from the very beginning, but here in IBC the control parameters change altogether. Next point of distinction is with respect to the mechanism for the recovery. How do they recover? So here in Sarfezi, if we talk about, there is they recover through the enforcement of security, settlements, restructuring, or change in the management. So there were six criteria or the six functions which were given. So any of those functions can be utilized for the recovery mechanism. And typically these are unilateral and outside the court. However, in case of IBC regime, they are the mechanism for recovery is collective judicial process. So it is nothing done on its own, because every time you have to take the approval of NCLT. So resolution plan is approved by COC and NCLT, and then it may involve restructuring also, sale as a going concern, or liquidation. So anyhow, whatever you are trying to do, you have to take the permissions of NCLT to finally dispose of the things. Next is regulatory supervision. So, who is the regulatory authority here in Sarfezi? Every kind of action of ARC is controlled or regulated by RBI master directions on this ARCs. However, in case of IBC, it participates within the IBC framework regulated by IBBI and supervised by the NCLT. RBI here continues to regulate the ARC itself. So RBI will be continuing to regulate the ARC. However, the functioning will be, regulated by IBBI, or it will be supervised by the NCLT. So there are lot many authorities under which ARC has to work in the case of IBC regime. Next, talking about the investor structure. So as we have earlier also discussed, as soon as the NP accounts are taken up by the ARCs or the asset reconstruction companies under SARFACI, they issue security receipts to the qualified buyers, that is banks or the financial institutions, etc. And the recovery, whatever they finally recovered, that is distributed in proportion to the security receipts holdings to the banks and all. However, in case of IBC, what is the structure? So here they may invest via security receipts or AIFs, or participate directly in the CIRP as resolution applicant, bringing own funds or co-investors capital. So when they are giving their resolution plan, they may have their own funds, how that will be distributed. They can have the proper plan mentioned there, or they can even have a co-investor funds also involved, detailing how that shall be distributed. So that is how the investor structure could be. Next points are with respect to the nature of assets handled. In case of Sarfezi, mainly the vintage NPAs, so which are very old NPAs are transferred after long default periods, and they often have very low value assets. However, in case of IBC, it starts at a very early stage. So involvement in recent large or systematic defaults under CIRP, where revival potential is much higher as compared to these vintage NPAs. Next is power to reconstruct. Here in SARFACI, Section 9 of SARFACI allows change of management, debt reconstruction, or takeover or lease of the business, conversion of debt to equity, settlement of dues, etc. However, in IBC regime, IBC allows comprehensive restructuring, includes haircuts, conversion, mergers, demergers, and capital infusion also under the approved resolution plans. So everything can be done in IBC, but only through the resolution plan. Once it is approved, anything can be done here. Next is regarding the speed and the finality. In SARFACI, there was no fixed time, or there is no fixed time limit. It often gets prolonged due to litigations or borrower resistance. However, IBC, as we all know, it's a very time-bound process, though at times it delays, the process gets delayed. But however, the origin or the basic objective is that it is very time-bound process. So 330 days for CIRP with extensions, and it obviously ensures the certainty of the outcome. Regarding the judicial involvement in SARFACI, it is limited to the appeals before Debt Recovery Tribunal under Section 17 of the SARFACI. So, if at all any appeals are to be made, that is made before the DRTs under Section 17 of SARFACI. However, in case of IBC, everything is driven by NCLT. So NCLT, their NCLATs and all. And ultimately, it is the commercial wisdom of COC which will be taken up in the supreme manner in all the cases. Regarding the outcome orientation, in SARFACI, it focuses on the recovery value. So liquidation and enforcement are very, very common here. However, in case of IBC, it focuses on the revival and going concern value, that is maximizing the enterprise value. So here in these, in these slides, we have discussed the role of ARC is altogether different when we talk about its role in SARFACI. While if it is functioning under IBC, the objective of IBC will be taken up as the supreme, and thereby it has to work under the methodology or things which are mentioned, or the provisions which are contained as per IBC. There are some more points regarding the stakeholder coordination. Regarding the stakeholder coordination, it is bilateral. So ARC and borrower, with the limited coordination among the multiple lenders, they take the control. Here in IBC, it is collective. So all creditors represent the committee of creditors. ARC may be one of them, or maybe it is the lead resolution applicant. So the control is altogether different, or the coordination works in a different way here. Regarding debt aggregation, it is restricted in case of SARFACI because it can only acquire from the banks or financial institutions. However, in IBC, the scope has been expanded, and here the debt can be acquired from NBFCs, AIFs, mutual funds, FPIs, etc. So the debt aggregation scope has been far more extended in the case of IBC. Let's talk about the governance and oversight. So we already know that in case of SARFACI, in case of asset reconstruction company, RBI will have the control over them. So it has strengthened post RBI Committee 2021 and Master Direction 2024, which makes mandatory IAC, that is internal committee is made, internal audit committee is there, independent board oversight will be there, transparency and OTS will be there. So these are the three major changes which have taken place through this Master Direction 2024. We will see that also in later parts of our slide. So because that is the governing of ARC, they have to abide by this RBI master directions from time to time. So whenever they are participating in any resolution applications or anything, in that case they have to abide by all these things. So if it is below 1 crore, they do not have to involve the board of directors. But if it is going beyond 1 crore and they are falling into this IBC regime, then every time they have to take the permission of the board, and then they have to work under this IBC. So they are governed by the IPC transparency and disclosure norms. Resolution plans are public. Here they are subject to the NCLT scrutiny and IBBI regulations. So the end goal in both of these is different. In SARFACI, here they try to recover the maximum dues for the lenders and investors, while in IBC, what they do is they ensure resolution of the corporate debtor with maximization of the value for all the stakeholders. So that is what we were discussing about the different roles in SARFACI and IBC. So as we all understand that ARCs, the asset reconstruction companies under IBC Act, can act in three major capacities. That is, they can act as a financial creditor, they can act as a committee participant, that is, they can be a part of COC, and they can also become a potential resolution applicant. So the whole success of IBC depends on the documentation, integrity, eligibility, compliance, and professional coordination between IPs. So finally, the systematic due diligence, the usage of information utility, evaluation transparency, and proactive communication are the keys to smoother the resolution process when it comes to the ARCs. So here now in the forthcoming slides, we will see how it plays the role of all these three capacities in all these three capacities, and how and what are the checkpoints wherein IP has to be very, very careful. And at the same time, ARC also has some challenges, or maybe IPs have some challenges, and how both of them can come to conclusion, or both of them can resolve those conflicts. So let us understand the role of ARC under IBC stage wise. So let us first understand the pre-CIRP stage, that is debt acquisition and initiation stage. So here the role of ARC will be like they will acquire NPA accounts from the banks or financial institutions under SARFAC. They will now become the assignee, and they can conduct the due diligence on loan accounts, security, and pending litigation. So on their own, they can conduct all this. And then after acquisition, ARC may initiate CIRP under Section 7 as a financial creditor. So this is the starting point if we talk about IBC. So before that, what has taken place is they have, first of all, ARC will take up the NPA accounts from the financial institutions. They will on their own conduct the due diligence regarding the loan documents, security, and if any litigation is going on, or they will identify where the assets is, or everything they will do on their own, and then they can file the application under Section 7 of IBC in the role of financial creditor. So what is the legal responsibility of ARC here? So they have to prove the existence of the financial debt and default, because when they are filing an application, they have to prove both of these things. First, that there is a financial debt, and second, there is a default. So both of these have to be established by the ARC itself. So what is the best practice here? File Form 1 with evidence, assignment deed, proof of payment for assignment, banker's book entries, the information utility record, the default notice, etc. So this is, the things which are takeaways for the IPs at the time of filing the application, what you must understand. So for filing the application for or on behalf of ARC, you should have these kind of evidence with you. The assignment deed, which is very, very important. The proof of payment for the assignment, that means they have given the security receipts for the assignment. Then bankers book entries in the books of banks, what is finally disclosed. So that is also required to be, undertaken. And then it should be there in the information utility also. And again, the default notice also should be there. So everything you should, and maybe there are many other things which you can take care of, but this is the, very, very important, or the minimum requirement which you should be aware of, that these are all we have to abide by while filing any application for Section 7. Next, or by, at times we give consultancy also to ARC maybe. So in that case, we have to be thorough with this. Next is stage 2, that is admission and appointment of IRP. What is the role of ARC here? So the role of ARC, once CIRP is admitted, ARC will be considered as an applicant and can propose an insolvency professional as IRP. ARC becomes part of the COC if other creditors exist, and if there are no others, then it will be the single person in the COC. What are the rights of ARC at this point of time? It has a right to attend the COC meetings. It has the right to vote according to the share of the financial debt as per Section 21(2). ARC has the right to inspect the documents and approve the costs or extensions. Just like any other COC, it is just a COC or a member of COC. So for each and everything which IP is doing in regular activities or day-to-day activities, they have to seek the approval from the COC, from the ARC here in this particular context. So for the appointment of any professional, or for the actually fixing of the remuneration for any of the professional services which you are taking up, or for any kind of extensions if you are going to, then you need to have proper documentation, and you have to disclose each and everything in the COC meetings. That means in front of the asset reconstruction companies. So there has to be a coordination between IPs and ARC at this point of time. So ARC and IP must align on claim verification, valuation process, and information sharing. So everything should be transparent, everything should be documented and properly communicated by IP to ARCs. And similarly, if IP needs or seeks any kind of information, they can seek, proper coordination from ARC or proper cooperation from the ARC with respect to any documents or any details they require. Next is stage 3, that is CIRP, stage of management claims and resolution. So what does it say? What is the role of ARC here? As a COC member, they can participate in the evaluation of the resolution plans. They can vote on the approval or rejection of the plans. They can protect the recovery and SR holders' interest. So that is the key functions, or these are the key functions if they are acting as a COC members, or these are the rights which they can have. Next is, as a resolution applicant, what could be their role? So first is they may submit a resolution plan alone or via consortium, provided they fulfill the eligibility criteria under section 29A. Next is they must show financial capability, credible revival proposal. So first is they themselves should be qualified to become the resolution applicant, and then beyond besides their own eligibility, they have to show the financial strength, financial capability also to revive the proposal or to bring the proper resolution plan. Next is the strategic advantage. If we talk about the ARCs here, often have sectoral expertise. So while selecting the resolution applicants, we go through the evaluation metrics. We check that. So if you have an application from, if you have a resolution plan from these ARCs, they can be considered as expert in that particular field because they are already into that kind of business of resolving the entities or maybe doing the recoveries from for them. So that is why it is mentioned here that it can be taken as a very strategic advantage if you have any resolution plan from ARCs. So ARCs often have the sectoral expertise regarding valuation know-how and access to investor network. So it enables faster resolution process. So thereby we can take advantage if there is any ARC involved in the whole resolution process. Next stage is post-resolution or the liquidation stage. What is the role of ARC here? If plan gets approved, in that particular case, ARC will receive the payments or securities as per the approved plan. If liquidation is ordered, ARC, which is the secured creditor, it can relinquish the security to liquidation estate and receive the proceeds, or it can enforce the security interest outside the liquidation. So here in the stage 4, we are considering that ARC is a financial creditor. It has filed application under section 7. And if the plan gets approved, ARC will receive the payments or securities as per the approved plan. Or if any liquidation has been ordered, in that case, it will have the option to either relinquish the security to liquidate to liquidation estate and receive the proceeds further, or it may enforce the security interest outside the liquidation. So both these things are possible. Regarding ARC and IP coordination in this particular regard, ARC must coordinate with the liquidator for distribution as per 53 waterfall mechanism. So if everything is going as per law, then there will not be any chaos. So ARC must coordinate with the liquidator or vice versa. Liquidator has to keep on telling the ARC the various parameters or the regulations which are there, and it should ensure the smooth procedure and distribution as per section 53 waterfall. Now let us understand what are the challenges faced by ARCs under IBC, because we have seen the role of ARC is different in SARFACI altogether. They are the whole and soul party in ARC in SARFACI. However, in IBC, they have a very limited role to play. Majorly, the control is there with the resolution professional, and they may even, they may act as a financial creator, or they may be part of the COC, or they may be the resolution applicant. So there may be challenges at each stage uh, which they are facing. So what are the challenges faced by them and how that can be resolved? We are here to understand that in these particular slides. So the first and foremost challenge will be regarding the proof of assignment and default. So while filing the application, as we have just now mentioned, that they have to submit the proof of assignment and default. So here NCLT insists on original assignment deeds, chain of title, and IU verifications. So missing documents lead to rejection. So that is a very, very challenging thing which normally they face, that they might be missing the chain of titles or things like that. So ultimately, if you want proper admission of your application, in that case, you need to have this proper proof of assignment and the proper proofs for the default also. So that is a challenge, and how we can overcome that, we have to think about that. The next is the multiple litigations or the stays. Here the borrowers challenge assignments or CIRP admission often simultaneously under DRT or SARFACI or high courts. So maybe simultaneous litigations are going on, but it is, we are talking before the CIRP admission. So after CIRP admission, it may happen that everything will come to standstill because of the moratorium. But till then, there may be various borrowers challenging for that particular thing. Next challenge which they face is regarding Section 29A disqualification risk. Here, if ARC is related to the borrower or promoter or shares or the shareholders or the directors, eligibility as the resolution applicant may be questioned. So this is what we all must check in Section 29A. If there is any resolution, if there is any prospective resolution applicant in the name of ARC, then we must thoroughly check whether they are related to any of the borrowers or promoters, or corporate debtor in short, or they are related to any of the directors or the shareholders. In that case, they will not be eligible to qualify as a resolution applicant under Section 29A. So everything has to be taken care. So only unrelated ARC can qualify under Section 29A, and besides that, there are other parameters also. Next is valuation disputes. What kind of valuation disputes could be there? Divergent valuations from different valuers create friction in COC decision and plan evaluation. Because being ARC, they might have done the valuation on their part, but when it comes under the IBC regime, again the valuers are appointed and they may give a different valuation. And therefore, it creates a friction or conflict in the COC decisions and regarding the evaluation of the plans. So what can be done in case of if we have different valuations, so whose valuation should be taken, and how to resolve those cases? So that becomes a very crucial point of conflict in these cases. Next is delay in admission and approval. So judiciary pendency at NCLT affects 330-day timeline. This we all understand. So sometimes it happens that even though they file application in IBC, they still believe that SARFACI was quite easy approach. But whatever, I mean, here this is a kind of challenge which they have put, that sometimes there is a delay in admission and approval, and once it is not admitted, how can the process be started? So that way they find it very challenging. Next is information gaps. Borrower data is sometimes incomplete, not sometimes, in fact, most of the time it is incomplete, and IU entries are also missing. So, how to deal with those cases? And in normal CIRP cases also we find the same thing. So again, this is a challenge which they face because they will not be able to cooperate with the IPs in case the data is incomplete. They don't have the data themselves, so they will not be able to pass it on to the resolution professional and all. Next is conflict of interest if ARC is both creditor and the resolution applicant. So we must ensure that there is proper transparency. There should not be any conflict of interest. A person cannot act as both. So that is something we all must understand. Next is distribution disputes. So sometimes with respect to the waterfall mechanism also, there may be disputes. So during plan approval or liquidation, disputes on priority regard or the SR holders sharing arise. So who will get a priority, whether it is secured or not, or what will happen, or at which stage I have to be, the funds have to be distributed to me, and all these kind of things can put challenge in front at the time of distribution of the proceedings. So that is what uh, the challenges which are faced. This is just a an illustrative list. It is not a complete list, obviously, but these are the challenges faced by the ARCs in there if they opt for IBC. Now, simultaneously, we should also understand what are the challenges faced by IPs if they, they have this ARC at any point of time in any of the roles. So the first thing again is the verification of the ARC claims. There is difficulty in verifying the assignments, consideration, and the right chain of the claims. Then next is COC constitution, determining the voting share where the debt is split between bank and ARC. If there is no proper mention in the agreement how this has to be split, or there is no proper agreement between these two parties, then obviously there is a challenge how to form the how to give the voting shares. Then next is regarding the information memorandum preparation. There is lack of cooperation from the corporate debtor or lenders, or they sometimes it happens that the lenders delay the process. So that is why it has become a challenge in this case, that if there is no cooperation from the corporate debtor or the lenders, how will the information memorandum will get prepared? So this is again in normal scenario also we see that, and here also it is the same thing. Next is the valuation and confidentiality, managing the independent valuers, defending the methodology. That is again because we have just now discussed that there are different valuers. ARC may say that they have a different valuation from their side. Here, when the independent valuers are appointed, they may adopt a different methodology altogether, and the valuation may be, different with what ARCs have quoted earlier. So that is again a challenging thing which has to be, settled at some point. Then next is litigation overload. Multiple appeals during CIRP reduce focus on the resolution because there are many stakeholders. So and litigations keep on continuing. So in that case, in order to, you cannot focus your energy on one thing if a lot of litigations are going on or multiple appeals are going on. So that is what it is said, that it is a kind of challenging situation for the IPs here. Next is section 21A screening. So how an IP can make sure that ARC who has applied here as a resolution applicant is not disqualified. So there is, it is a very challenging to analyze each and every qualification criteria. So ensuring RAs, including ARC, meet the eligibility before the COC vote. Uh, Sometimes it is very difficult to ascertain whether they are related or not. So if from each and every angle, this has to be checked. Next is communication breakdown, inadequate coordination between IP, ARC, or banks or other creditors. So obviously, communication is the basic key. If you do not have the communication channel with any of these, like if there is no proper communication between ARCs or banks or any other creditors, or between IP and ARC, then this may result into communication gap, and then obviously it may result into various conflicts and not reaching to a proper resolution in time. So that is why it is mentioned that these are the challenges faced by the IPs. On the other hand, once we have already seen challenges faced by the ARCs. Now, what could be the best practices which we can take up in this particular scenario? So, regarding the documentary or the proof of debt, so in that case, the suggestion could be to maintain digitized repository of assignment deeds, notices, consideration proofs, then file the information utility information immediately post the assignment. So that is something which we all must take care of, that as soon as any case comes up in the IBC, that proper chain of documents should be there, proper assignment deed should be there, notices if any, issued, any kind of proofs for consideration, that is also to be contained, and it has to be filed at the information utility also. Then next is litigation or coordination, because we just now saw that there could be a possibility of multiple litigations going on. So in that case, use joint lender forums for aligned strategy, ARCs and IP to share all the pending litigation data. So nothing should be kept, hidden. Everything should be disclosed, and it should be even disclosed in the information memorandum that litigations are going on. So that is something which we should not hide, and we should try to get it synergized by taking help of various joint lender forums. Next is Section 29A compliance. So with respect to the disqualification criteria, or who will be the eligible resolution applicant in that case, it is very important to obtain legal opinion pre-submission of the plan. So if there is any doubt or if there is any difficulty, then in that case we can obtain the legal opinion uh, prior to the submission of the plan. Here IP has to insist on 29A affidavit with supporting documents. So the IP may insist the ARP to submit affidavit on his part and provide the supporting documents also. So sometimes it becomes very difficult how to assess this 29A criteria, because we have to check, there is no proper repository wherein we can check everything is, correct, or this party is totally unrelated. Normally what we are doing is we are obtaining certificate from a third party who is doing the 29A compliance. That certificate is not reliable altogether, because ultimately uh, being an IP, you cannot shrug off your liability saying that we have obtained that certificate which says that it is 29A compliant. At any point of time when it is revealed that this ARC or any other person who's the resolution applicant is non-compliant, then in that case, IP will be considered guilty, and it will be assumed that you have not followed your code of conduct, you have not followed the rules and regulations, and disciplinary actions can be taken upon the insolvency professional. So just by taking the certificate from a third party regarding the 29A compliance will not suffice the purpose. To keep that in better position, what you can do, that you can ask that third party to give the supporting documents along with that certificate, where all it has inquired, how it has reached to that conclusion, what are the evidences to show that this is the conclusion as per the certificate which they are giving, that this party is 29A compliant. So not only in the case of ARCs, but in normal cases also, we should try to do this, because ultimately it is the responsibility of the IP to check this 29A compliance. Next is regarding valuation disputes. So regarding valuation, we have just now uh, discussed that there could be disputes because ARC has done valuation in a different scenario, with using different methodology maybe, and the new valuers which are appointed under IBC, they are taking it up in a different manner altogether. So in order to settle the matters in these cases, it is better to follow the ICI valuation standards and IBBI valuation rules as per 2017. And it is very important to appoint at least two independent valuers for valuation purposes. And again, it is a best practice to appoint valuers as soon as the admission takes place. And even for the separate class of assets, you should have separate valuers so that the work will become easy and nothing will be missed out. So everything has to be taken care within the limited time frame, and that is why we have to be very, very cautious. We should try and avoid any kind of disputes. When we already know that in case of ARCs, there could be disputes with relation to valuation. So in that case, we must try and figure out situations, or we must try and figure out those things wherein we can, restrict these kind of disputes or try to minimize these kind of disputes. Next is admission delays. With respect to admission delay, it happens only because we do not have sufficient proofs to showcase. So pre-file the complete record and rely on the IU evidence to speed up the adjudication. So obviously the preparatory work has to be done in a very good way so that the admission is not delayed and the process starts off very smoothly. Next is information gaps. COC may authorize forensic or transaction audit, seek data from the statutory auditors. So in case of information gap, what is suggested is COC may authorize the forensic or transaction audit, which obviously IPs or the resolution professionals they start, and because they are these transaction audit and the forensic auditors, they are experts. In case you do not, if you want to go and find out the PUFE transactions also, and if you don't have enough data with you, then you should always seek help from these people. So you can seek data from these guys, or if there is any other regulatory authority from whom you can get the data, that can also be done. So in case of information gaps, this is not just with respect to ARC, but also in general scenario or general parlance, we can say that sometimes we, not sometimes, mostly in all the cases, we file 19(2) applications, which is the non-cooperation from the corporate debtor or the other parties. So in that case, that is one part. Filing the application is one part, but we cannot just wait for that, and we cannot say that since we have filed that application, we do not have sufficient documents, we can delay the process, because ultimately to complete the process in time is our responsibility, being the insolvency professional. So how to speed up the process? Even if you do not have the sufficient information, you should try various other sources also to seek the information. So nowadays it is advised again and again that uh, there are many statutory departments wherein you can get the statutory authorities, from where you can get the data. Like from MCA, you can get the data. From GST authorities, from income tax authorities, you can get the financials of any of the corporate data, or from the previous auditors also. You can seek data from them. So yes, auditors, the statutory auditors are bound to give you the information. Uh, and you are the officer of the court, and you can get these information because you have to speed up the process of the CIRP. So that is how you must proceed. One part is filing the application under 19(2), but at the same time you have to go and collect the information from various other sources from wherever you can get. Even from the banks you can get the information, because they have the updated information. I mean, till the date of default they have the details with them. Next issue is with respect to the transparency and ethics. Here, the suggested solution is IPs have to maintain written communication and disclosures to avoid any kind of conflicts. So these suggestions are not just for ARC, but in normal cases also, in any of the cases also, communication is very, very important. Documentation is very, very important, because nowadays many disciplinary actions are being taken against the IPs. So how will you prove that you have actually done your part. So it is only with your working papers, your documentation, the everything you can, showcase that you have done your part to the best possible extent you could. So every time whenever you are communicating with the any of the stakeholders, even on the phone or on the mails, you have to get that documented. So any verbal settlement has taken place, maybe that has to be, finalized in the form of a written document. You can from your side send a mail saying that this is what we have discussed and this is the conclusion we have reached to. Kindly acknowledge, so that way you will have a proper documentation in order to avoid any conflict in the future. So that is how it should be taken up. Moving further, this is the precautionary checklist which we all must understand if we want to take up any kind of assignments with the ARCs. So before filing CARP, the action item could be to verify the assignment deed, stamp duties, payment proof, borrower notice, information utility record of default, everything whether it is in place or not. So before filing the CIRP application, we must have this thing. So this is a kind of checklist which you all can take the screenshot of, or maybe you can note it down. Next is regarding claim filing. You have to submit Form C to IRP or RP with all the annexures, assignments, chains, loan documents, ledger, interest computation, and everything. So since claim filing ultimately will have to be done by the ARC because they are acting in the shoes of financial creditor. They have to file their claim. So what all annexures they have to submit so that their proper amount, full amount, whatever they have claimed can be admitted. So all these things they have to take care of. Next is during COC participation, what ARCs can actually take care of. They have to attend meetings. It's better to attend meetings to have the knowledge whatever is going on. Next is to record dissent if any, because it has to be minutized properly. Everything is to be there in the minutes. If anything, if you are not assenting to anything, that has to be taken note of. Then ensure voting instructions from SR holders recorded in writing. So everything should be there during, it's an active participation is required from the ARC during the meetings. Next is if acting as the resolution applicant, if are acting as a resolution applicant, in that case, they have to, first of all, themselves check the 29A compliance. Wherever they think they are disqualified, they should, try and correct it if possible. Or if they are not qualified, they should not file as a resolution applicant altogether. And again, if they are qualified, then they can prepare the expression of interest, or they can plan with the full disclosure, obtain the legal opinion on their eligibility. So if there is any confusion, you can always go for obtaining the legal opinion. Otherwise, it will kill a lot of time. Next is in case of liquidation, what is the role of ARCs? What is the precautions which they can take up? So they should decide whether to relinquish or enforce security beforehand itself. It should not be a decision taken afterwards. So and then they can file Form D claim, ensure valuation and release documents also at proper time and place. Next is post resolution. What is their role and responsibility, or what precautions they should take care of? They should maintain proper record of recovery, SR redemption, plan compliance, file necessary RBI or trustee reports. So that is how they should do at the time of post resolution. Regarding IPs, what are the checkpoints for the IPs? In case of admission, at the time of admission itself, they should verify the completeness of the ARC documents, assignments, the same thing, which we have studied from the point of view of ARC. That same point applies to us also. So in case of insolvency professionals, they have to take care, or they should understand that completeness of the records is very, very important so that the application gets admitted. Next is constitution of COC. At that time, voting share should be computed accurately, uh, checking out whether the ARC is related or not or whatever. Include only verified financial creditors. So that is a checkpoint for them. Next is regarding valuation. IPs must appoint two registered valuers and they should follow the ICAI or IBBI valuation standards. Again, I must quote here that even if you are taking help of the valuers for doing the valuation, again it is your responsibility to it is the IP's responsibility, in fact, regarding whatever the valuation report is there. You cannot say that this valuation report was prepared by some third party. Again, it is your responsibility whether it is following the IBBI valuation standards, ICI standards or not. So if it is not following those parameters, then again it is a loophole on the part of IPs. So that is what they have to make sure of. Next is resolution applicant screening at the time of section 29A screening. What is the role of IP? They have to collect 29A affidavit and supporting documents before placing a plan to the COC. And obviously, it's not just taking the affidavit or supporting document. It can even seek information from the prospective resolution applicants wherever it thinks or he or she thinks. And simultaneously, on its own, also inquiries can be conducted to satisfy whether Section 29A criteria is sufficiently fulfilled or not. Next is COC conduct. Here, IP has to ensure that minutes are properly prepared, timely prepared and circulated, and every important point is mentioned in the minutes. Any dissent or assent, whatever was there, whatever the point of discussion was there. So everything has to be minutized. Then what is the result of the voting? That is also proper documented. And how the conflicts were handled in the meetings, that should also be taken on record. And who was absent, who was present, obviously we take that on record, no doubt about it. There are some more checkpoints for IPs only to avoid conflicts. What they should do is record all professional fees and third party engagement, disclose any relationship with the ARC, if any. So if there is any relationship with ARC, obviously they have to disclose that regarding the professional fees and third party engagement, because every time you have to take the approval from COC, you should record each and everything. And documentation, as we have already discussed, is very, very important. Next is litigation management. Litigation management will ultimately, help in value maximization ultimately. So if there are less litigations and you are able to settle the conflicts then and there, then obviously it will help you to get the maximum value. So keep a tracker of the pending applications, NCLT or NCLAT. Seek legal opinion as early as possible. Wherever you have doubts, you can seek the legal opinions. You can even take opinions from your peers or from IBBI. Nowadays, they have also issued FAQs. Wherever you have doubts, you can simply check those FAQs and you can get your problem resolved out of it. Next is regarding closure and reporting. IPs are supposed to file the final report, compliance certificate, and communicate plan approval to all the stakeholders. So this is what is required on the part of IPs. At this point of time, I think we can take a break, or maybe we can finish off with this slide and then we can take a break. Practical coordination points in both for both of these parties like ARC and IP, how they can jointly work and what is the best practice which they can do in all these cases. Like pre-admission, we have understood that ARC has to submit the complete details regarding credit and security documentation, confirm the claim computation, everything. So the admission gets faster. Next, regarding the post-admission process, they have to maintain transparent communication. ARC has to provide inputs for information memorandum. The next is regarding plan evaluation. They should conduct joint meetings of legal valuation and technical advisors to avoid last minute issues. So communication is obviously the best thing which you can do in order to avoid any kind of conflicts. And again, you can have legal opinions to sort out your queries. The next and the last here is the implementation. ARC and RPs or the liquidator have to ensure the timelines for the payments and security release are properly adhered to. So with this, we can, I think, take a break here for 10 minutes and then we will resume at 11:40 to resume the session. If you have any doubts, you may post it in the chat box, or maybe we can unmute and answer that also. At 11:40, we will assemble. Thank you. Can we start?
Yeah, ma'am, let's start.
Yeah. Okay. So let me just share my screen. Just a second. Okay, so let us now understand the RBI circular, which was issued on 12th October 2022, wherein there were some specific guidelines which allows ARC to participate as resolution applicant. In that case, following conditions must be satisfied. So let us understand what was it. The related circular was this RBI circular number, as you have seen here, and it is dated 12th October 2022. I can increase the font size. Okay. So the title reads, RBI allows asset reconstruction companies to act as resolution applicants under IBC and following other key provisions. ARCs with a minimum net owned fund of 1000 crore may act as resolution applicant. So it is clearly mentioned minimum net owned fund of 1000 crore. They may act as a resolution applicant under IBC. So this is something which we all must check at the time when any application or any resolution plan is received from these ARCs. So whenever ARC is coming into picture, we have to be very cautious if they are coming in the role of prospective resolution applicant, or when they are showing their expression of interest that they really want to participate. In that case, we have to make sure that they are fulfilling this criteria. This is the first criteria. Second is ARC must have a board approved policy for submission of the resolution plan. So again, we must demand from them. If they are not giving it to us directly, then we can demand from them that there has to be a proper board resolution or board approved policy for the submission of the resolution plan. So if they have not taken into record that whether they are eligible to submit resolution plan or not, for each and every case they have to have this in their board approved policy. For each category they must have is that board should first approve that they can go for this filing of resolution plan. Next is ARC must ensure that within 5 years from approval of the resolution plan, they shall not retain significant influence or control over the corporate debtor. See, this point is very, very important because if they are not fulfilling this particular point, their license may be cancelled by RBI, because RBI has laid down this guideline saying that ARCs must ensure that within 5 years from the approval of the resolution plan, they shall not retain significant influence or control over the corporate debtor. So somehow they have to, delegate, or they have to distribute their stake to the others, because it is not the main function of ARC to gain control or have the significant influence over the corporate debtor. So they have been given 5 years from the date of approval of the resolution plan. So within that time frame, they have to abide by this. Otherwise, their license can get cancelled. And it is to be taken into very much consideration that if this kind of ARC, which is already, its license could be disqualified. I mean, if it might be in the process of cancellation, the license could be cancelled by RBI. Maybe the steps are being taken in that regard. So whenever any ARC is applying in the role of this prospective resolution applicant, you should again check whether it has earlier applied for some other corporate debtors resolution also. So if it has applied elsewhere also, then again Then again, what you need to check is whether they have, from the date of that particular or the earlier resolution plans of the earlier entities. I mean, within 5 years, whether they have transferred the significant influence or control, or they are still having that. So, like in case of directors, we check whenever we form a company, we check the qualification of directors, and we check the related parties. I mean, if a director is already, if a person who wants to be a director in a particular entity and he is already director in some other company, and that other company has been disqualified, or it has not been proper filing the reports and all, so director can be disqualified from this company as well. So similarly, I mean, on that parameters itself, it is not just one on isolation. We cannot check the ARC criteria for eligibility. We have to check whether in past also they have applied for any resolution plans in any other entities, and whether proper I mean, these guidelines have been properly followed or not. If they have not been properly followed, then obviously you should restrain yourself from taking them as resolution professional resolution applicants in your case. Next is ARC must disclose details of implementation status of resolution plans, additional disclosure in the financial statements when participating as a resolution applicant. So disclosure requirements are also there, which are laid down. We will check the proper circular which is there, and they must disclose the details of the implementation status of the resolution plans, the earlier resolution plans which they, if they have all given in the past, what is the actual status of those. In the additional disclosures, they have to file that, and in the financial statements also they have to disclose that. Then next is other governance enhancements. For example, independent director point is there. Every ARC should have independent directors. Minimum two directors, independent directors have to be there on the board. So, and NOF uplift, this net own fund requirement is the criteria. 300 crores is the minimum threshold limit, etc. Whatever is there. So let us directly check the main circular. I'm just sharing my screen again, wherein we can check the proper circular. The exact wordings we will also come to know. Just a second. Just let me know if my screen is visible. Can you all see this RBI circular? It is running into 50 pages.
Yes, ma'am. We can
Yeah.
see.
Yeah. So it was issued on 2020, 1st April 22, and then updated, and then again it was updated, and all it is mentioned there. So we are here to see directly. We will not take up the whole things which are mentioned here, but it contains each and everything regarding ARC. If you want to understand anything about the asset reconstruction company, then everything is mentioned here. What is the applicability, definitions, registration, net own fund, what is meant by that, then what is the permissible business they can enter into, then what is securitization, what is asset reconstruction, everything. We are to discuss this 26 and 27 point directly, because this was the major change in this particular circular. So let us go directly to that. Let me just quickly reach to that point and then we will start. So this is the corporate governance framework. So the governance part has also been become more strict with respect to this circular. So even that has to be, taken care, because if you are not following these provisions at any point of time, the certificate which was issued by RBI can be cancelled. So at any point of time, I mean, that is what we have to be one step ahead of others. We should check the proper governance framework of these, whether our ARCs are properly conducting meetings of their board of directors or not. And we should check all these parameters also if we are getting them as resolution applicants. So here it is mentioned that the chair and the meetings of the board of directors, the chair of the board shall be an independent director. In the absence of the chair of the board, meetings of the board shall be chaired by the independent director. Quorum of the board meeting shall be 1/3 and all. So this is the criteria which is given regarding the meetings. Then what shall be the tenure of the managing director, chief executive officer, all that is defined. Moving further, the age limit is also there. Who can be the managing director? What shall be the maximum age? Then next is the performance review. The performance of the MD, CEO, or the whole-time director shall be reviewed by the board annually. So whether all these are actually being taken or not, that is something which we can, ask. We can ask the reports of that. The next is with respect to the committees of the board. Various committees are to be formed here. So in order to strengthen the oversight by the board, the all ARCs shall constitute the following committees. So there is no exception. All ARCs have to constitute following committees. First is the audit committee. We should understand who will become the part of the ARC's audit committee. Here it is mentioned that it should comprise of non-executive directors only. The chair of the board shall not be a member of the audit committee. The audit committee shall meet at least once in a quarter with a quorum of 3 members. I'm not getting into the details, but this is one of the committees. Then they also have the nomination and remuneration committee. I mean, all these committees we have heard in the companies. Since Companies Act is also applicable on them, we have just understood that ARC first they have to register as a company, and then they have to follow SARFAESI or RBI. Then here again, they are taking the provisions of Companies Act itself, that you have to abide by all these provisions. Then here it is mentioned regarding the transition period. So there is something regarding transition period. ARC that were not in compliance with the guidelines prescribed at paragraphs 26(1) and 2 above as on October 11, 2022 are required to comply with these guidelines latest by April. So this time limit has already gone, so they must have complied with it. It's not relevant. Then fit and proper criteria for the directors and CEO. Who can be a qualified person, or who will be the eligible person to become the director and CEO. So these are also laid down by this circular. Then next is here we have to put focus on ARCs act as resolution applicant under Insolvency and Bankruptcy Code. So this is what we are supposed to be knowledgeable about. In terms of the provisions of Section 10(2) of the SARFAESI Act, ARCs have been permitted to undertake those activities as a resolution applicant under IBC which are not specifically allowed under the SARFAESI Act. So even if they are not allowed under SARFAESI Act, they can act as a resolution applicant as per this circular. This permission shall be subject to the following conditions. So this condition shall be, so this permission is conditional. So if you fulfill all these criteria, then only you can act as a resolution applicant, otherwise you cannot. So this is what we must understand. The ARC has a minimum net own fund of rupees 1,000 crore. So that is the main point which we should all understand, that even if anyone can form ARC with 300 crores minimum net own fund. However, if you want to apply as a resolution applicant, in that case, you should have a minimum of 1,000 crore net own fund. That is the criteria given here. Otherwise, they are not allowed to participate as a resolution applicant as per the RBI circular. Next is ARC shall have a board approved policy regarding taking up the role of resolution applicant. So again, this has to be just like we have, proper resolution, board resolution is to be passed for this particular regard that you want to participate as a resolution applicant uh, anywhere. So that is that is to be mentioned, or that is to be obtained by the IPs on a safer side. So you can seek these kind of information. Board approved policy regarding taking up the role of resolution applicant, which may inter alia include scope of activities, internal limit for sectoral exposures, etc. A committee comprising of a majority of independent directors shall be constituted to take decisions on the proposals of submission of resolution plan under IBC. So for if I mean any board approved policy is there, in that case they will also form a committee with independent majority directors uh, who will be responsible to take the decisions on the proposals on the resolution plan under the IBC. So separate committee should be formed. So all these points you should ask or you should take you can seek information from the ARC whether a committee has been formed or not, or whether board approved policy is there or not. The ARC shall explore, fourth point, we are on this fourth point, the ARC shall explore the possibility of preparing a panel of sector specific management firms or individuals having expertise in running firms, companies which may be considered for managing the firm's companies if needed. So ARC should also explore the possibility of preparing a panel of sector specific management firms. So again, they can have a separate expert panel for any sector specific requirement. So they should be having that kind of panel so that wherever required, you can also seek their help and guidance how they are handling the situation, because sometimes we are not thorough with the proper industry requirement. So ARCs are mandated to have this kind of panel if they actually want to participate as a resolution applicant. So in that case, they will be having a separate expert panel for themselves. Next is in respect of a specific corporate insolvency resolution process, the ARC shall not retain any significant influence or control over the corporate debtor after 5 years from the date of the approval of the resolution plan by the adjudicating authority and the IBC. This we have already checked earlier also. In case of non-compliance with this condition, the ARC shall not be allowed to submit any fresh resolution plan under IBC, either as a resolution applicant or as a resolution co-applicant. So in both the case, even if he is not a primary resolution applicant, can he act as a co-applicant? No, he cannot. If he has not fulfilled this condition of these 5 years, he has to hand over the control and management to some other, then he will not be allowed to take up the role of a resolution applicant at any point of time. Next is the ARC shall make additional disclosures in the financial statements with respect to the assets acquired under the IBC in addition to the existing disclosure requirements. So whatever they are already disclosing, they will have a separate disclosure in their financial statements that is going further. These would include the type and the value of the assets acquired in the IBC, the sector-wise distribution based on the business of the corporate data, etc. So this is for their disclosure requirement. So again, if they had already applied elsewhere as a resolution applicant and they are coming to you as a resolution applicant, then obviously you can take that in their financial statements, whether they are disclosing about the earlier resolution plan or the the other assets which they have acquired during IBC. So that has to be there in their financial statements. Next is the ARC shall disclose the implementation status of the resolution plans approved by the adjudicating authority on a quarterly basis in their financial statement. So it is a regular updation which they have to do. So this is all the major thing which we must understand with respect to this circular. All right, so this is one thing which we had to understand, that whether ARCs can become resolution applicant or not, and if they are becoming a resolution applicant, what are the conditions they have to fulfill. And this is In addition, I mean, we have to check it in addition of section 29A. While checking 29A, the eligibility criteria, we have to check specifically for this thing. Now, let us quickly check some of the judicial cases or some case laws. Therein, ARC is in role, and what is there, what is the takeaway for all of us? We must understand that. Just a second. I hope my screen is visible. All right, should we go ahead? The first case is Supreme Court of India. I mean, it's a Supreme Court decision. It is between Asset Reconstruction Company India Limited, that is ARCIL, versus Tulip Star Hotels Limited. And it's a decision of 2022. Let us discuss the facts of the case. A consortium of banks lent to Tulip Star Hotels Limited, which is the corporate debtor. In 2002-2003, the account was declared NPA on 1st December 2008. The bank-led consortium assigned its receivables to ARCIL. So this ARCIL is the Asset Reconstruction Company, and to this the bank had assigned the receivables on 31st December 2008. In February 2011, within 3 years of NPA, the corporate debtor sought extension of time for payment and acknowledged the liabilities. Its books of accounts and balance sheets between 2008-2009 and 2016-17 recorded the liability to ARCIL. Otherwise, I mean, these are old dates, so Limitation Act would have also come into picture, but they have already taken the extensions and all, and it is properly there on the record. So ARCIL filed an application under Section 7 in IBC on 3rd April 2018. So what was the issue here? Whether the application under Section 7 of IBC by ARCIL was time barred by limitation, given that the account was NPA in 2008 itself, and whether acknowledgement in the books of accounts can extend the limitation. So again, obviously, we need to understand that it's only mentioned in the books of accounts whether the acknowledgement in the books of accounts is good enough to record that as a liability or a default, I mean, on their part. So what were the observations? The Supreme Court held that although a 3-year limitation period under the Limitation Act would apply, an acknowledgement of debt by the corporate debtor in writing before the expiry of the limitation would extend the period. The court observed that the entries in the financial statements would qualify as acknowledgement of the liability for the purpose of Section 18 of the Limitation Act. The courts thus held the application on 3rd April 2018 was within the extended limitation period given the acknowledgements. So that is very, very important. So if you have the acknowledgements, it will be assumed that the limitation period has been extended. So again, whenever you have any Section 7 application to be filed on behalf of this ARC, you should check all the records. When was the debt due? Whether the limitation period is over or not, and how it is being reflected in the other side. On the other side, I mean. So all that has to be taken care, and proper acknowledgements have to be there so that it still can qualify to be taken up as a default in IBC. So what is the conclusion? The Supreme Court set aside the NCLAT's order, which had held the application time bar. It held that ARCIL's Section 7 application was valid and not barred by limitation because acknowledgement of debt extended the limitation period. So this is a kind of takeaway for us. We need to ensure that the corporate debtors books financial statements reflect the liability and acknowledgements of debt or interest within the limitation period to preserve the IBC remedy. Moving further, next case, Phoenix ARC Private Limited versus Doshan Veolia Water Solutions Private Limited and others. It's a decision of 2021. Let us discuss the facts. L&T Infrastructure Finance Company advanced a financial facility of rupees 40 crores to Doshan Limited, which is the borrower, under a facility agreement dated 12th May 2011. The corporate debtor pledged 40,160 shares of Gondwana Engineers Limited in favor of L&T. That is the pledge agreement dated 10th January 2012. On 30th December 2013, so just understand the chain of events. First of all, L&T Infrastructure had advanced a facility to Doshan. It was done in 2011. Then this corporate debtor, Doshan, had pledged the shares, 40,160 shares to Gondwana in favor of L&T. So in order to receive that, receive the financial facilities, they have given this on pledge. On 30th December 2013, L&T assigned its right, title, and interest in the financial facility, including the security interest of Phoenix ARC. So here the assignment is done, and date is again very important for us to understand that it was done on 30th December 2013. Assignment was done by this L&T to Phoenix ARC. CIRP was initiated against the pledger, and Phoenix claimed to be the financial creditor. Here the RP rejected its claim, arguing the liability was limited to pledge of the shares, that is security only. So what is the issue involved? Basically, whether Phoenix ARC qualifies as a financial creditor of the pledger, that is the corporate debtor under IBC, merely by virtue of being assignee of a financial facility originally given to another entity, and by virtue of pledge of shares created by the corporate debtor, not a principal borrower in favor of the L&T. I'm just reading it again for the purpose of better understanding. Whether Phoenix ARC qualifies as the financial creditor of the pledger under IBC merely by the virtue of being assignee, since it was only an assignee for the financial facility originally given to another entity, and by virtue of pledge of shares created by the corporate debtor, not a principal borrower in favor of the L&T. So what was the observation of the court here? The court observed that the financial debt under section 5(8) of the IBC requires disbursement of money against consideration for time value of money, and the liability must be owned by the corporate debtor. The court held that a third-party security, that is pledge, by the corporate debtor does not automatically convert the pledgee into a financial creditor of the pledger. The corporate debtor must owe the debt. So that is very, very important here. This line is very important. The corporate debtor must owe the debt. The Supreme Court reaffirmed that the secured creditor must have a direct debt relationship with the corporate debtor, and being merely the security provider is insufficient. So what is the conclusion? Phoenix ARC was held not to be a financial creditor of the corporate debtor. Its claim was rejected. It could be at best a secured creditor, but not a financial creditor under the IBC. So what is the takeaway? ARCs must ensure that assignment includes a debt owed by the corporate debtor itself, and that the corporate debtor is the obliger of the facility. Mere creation of the security by the corporate debtor for a third-party borrower does not suffice. So in order to be in the position of financial creditor, the debt should be owed by the corporate debtor itself, and merely creation of this kind of security will not serve the purpose that was discussed in this particular case. Moving further for the next case. I think it is the same case, Asset Reconstruction Company versus Tulip Star Hotel. Here, what was another issue? Whether the entries in the corporate debtors' books of accounts and balance sheet constitute. Oh, this we have already discussed, I think. Yeah, it will be considered as time barred. So, I mean, broadly, we have discussed this. If at this point of time, any one of you have any questions, we can take up that as well. Any questions so far? Okay, so we can take up, just let me see if I have any other case also, we can take that up. Yeah, we have a case of Alchemist also. Just a second, let me share the screen. My screen is visible. Alchemist Asset Reconstruction Company Limited versus ASC Insolvency Services LLP and others. This is a recent judgment. The facts of the case are Alchemist ARC, a secured financial creditor of the corporate debtor, filed appeal challenging order approving the resolution plan and raising the points about the assignment of the debt to the non-ARC competition law issues, etc. Reading the facts again, Alchemist ARC, a secured financial creditor of the corporate debtor, filed appeal challenging the order, approving the resolution plan and raising points about the assignment of the debt to non-ARC competition laws issues, etc. So there were many issues. One of them was related to the assignment of debt to the non-ARC also. So what was the main issue we are dealing here with? Whether assignment of a debt by an ARC to a non-ARC is permissible under SARFAESI or the RBI directions. First issue is this. Second issue, whether Section 5 of the Competition Act applies to the assignment or the resolution plan approval context. So let us discuss the observations. NCLAT held that assignment of debt by an ARC to a non-ARC is not prohibited under the SARFAESI Act or RBI master directions, provided the assignment forms part of the approved resolution plan, and therefore the assignment itself cannot be faulted. So again, this is something very important to understand, that assignment from asset reconstruction company to a non-asset reconstruction company is not prohibited. Since clearly it is not mentioned anywhere, so it is not prohibited, and therefore the assignment itself cannot be faulted. On the competition law angle, NCLAT observed that the value of the corporate debtor fell below the statutory threshold, and thus prior approval under the Competition Act was not required. So we are not dealing with this Competition Act point, we are just dealing with this ARC point. So let us understand the conclusion. Appeal by Alchemist ARC was partly addressed since the first point is there. NCLAT reaffirmed that such assignments are permissible and clarified that competition law obligations may not be triggered depending on the value. Okay, this is something which we can leave. Next case, Asset Reconstruction Company India Limited versus Amrit Jal Ventures Private Limited and others. This is a case of 2021. ARCIL asserted claim via assignment deed of financial debt. The COC and RP disputed the assignment validity and voting share recognition. So the main issue here is whether assignment of debt by a bank to ARCIL, that is the Asset Reconstruction Company, and subsequent entry into COC sufficed for the recognition of ARCIL as the financial creditor, and whether the assignment itself can be challenged in a Section 7 petition. So again, I mean, here we need to understand whether this is a case of, since this is an assignment, whether it qualifies under the definition of section, I mean, whether he qualifies as a financial creditor or not. So NCLT here observed that NCLAT held assignment of debt cannot be challenged in a petition under Section 7 of IBC. That is, once assignment deed is executed and all formalities are complied with, challenge goes to separate forum and not at the admission stage. This helped confirm that ARCs acquiring financial assets under the assignment are generally eligible to seek CIRP under IBC as financial creditors. I mean, this point is very much clear. We have already seen that proper assignment, if it is there, proper documents, if they are there, then he comes into the shoes of, ARC comes into the shoes of financial creditors only. So ARCIL's claim was recognized here. The NCLAT emphasized that the detailed probing of assignment validity should not derail the admission under Section 7. Only prima facie satisfaction is required in this particular case. So again, I mean, this is the same thing. Yeah, we are done with the cases here. Now I have some FAQs to share. I mean, this could be the common issues which we might face. So just let me open the sheet. Yeah, okay, before that, there could be one more thing to be discussed. There are some key issues which we talked about, some challenges on the part of ARCs. So how to deal with them? We can even take that up also. Just a second. Yeah, so there could be 2, 3 main issues pertaining to ARCs, the challenges which they can face. One was with respect to the valuation part. There could be some conflicts with respect to that. Then there could be challenges with respect to the admission of the application because they don't have the proper chain of documents with them maybe. And there could be scenario wherein, time to time, RBI changes the regulations or they keep on bringing in more directions from their part. So evergreening or circular transactions and RBI enforcement risk is always there for them to address. So how to handle that? So let us understand this. In May 2024, the RBI barred 2 companies of Edelweiss Group, that is Edelweiss Reconstruction Company Limited and non-bank lender ECL Finance Limited, from acquiring financial assets or engaging in structured transactions because the regulator found they have been involved in evergreening distressed loans, that is issuing new loans to enable repayment of existing stressed loans or engaging in circular transactions and incorrect valuation of security receipts. So that kind of action can also be taken by RBI if they come across with such a scenario. That evergreening simply means, you are keeping that stressed loan alive. You are, continuing that loan again and again by issuing new loans to the entity. So RBI also warned ARC generically that some firms were being used as conduits for promoters or related parties to re-enter via distressed assets or circular transactions. For an ARC, under IBC, this creates risk of regulatory enforcement, reputational damage, and possible invalidation of assignments or the asset acquisition if circularity is proven. So if in any case that kind of thing is proven, action can be taken. So what can be the tips or the mitigation steps for that? So robust internal control and the compliance framework should be there. So establish clear policies to avoid transactions where the ARC acquires assets from entities related to borrowers or promoters or use round robin, that is funding via alternate investment funds or special purpose vehicle. The next point could be you can track counterparty relationship, ensure the originator or the seller to the ARC if it is a bank or financial institution as mandated by the SARFAC and not a promoter related entity or a non-lender conduit. Again, they should have a proper governance committee for the audit or monitoring committee in the ARC that reviews each major acquisition for risk of evergreening or circular transaction. So that is how they can take care of these things. Next is regarding due diligence on assignment chain. So how you can how you can check the this assignment chain altogether. So before acquiring the distressed loan, perform due diligence to check whether the borrower had received fresh money or restructuring from the same group, which may resemble evergreening. So that is very challenging to check at times. How will you how deep you will go into the transaction and you will check the original point of the transaction and then how many times it has been restructured and all. So that sometimes is very time taking, but again, if you want to be sure of, you have to do this kind of due diligence. And even ARCs, at the time when they are taking it up, they can also do this kind of due diligence on their part. Check that the assignment is not part of the same of a scheme where fresh funds flow back to the borrowers, promoters, or related parties in a disguised way. Document the substance of the transaction, purpose of the acquisition, source of the consideration, independence of ARC board decision, and separation from the originator promoter group. So, if everything is documented and you have sufficient evidence to prove all this, obviously you can get out of this thing. Next is regarding valuation and SR issuance discipline. The RBI in Edelweiss, just a second, sorry. Here we are. The RBI in Edelweiss case noted incorrect valuation of security receipt as a part of regulatory concern. So ensure that valuation of the underlying assets or the portfolio is properly documented, defensible, involves independent valuers, and follow the recognized standards. So wherever valuation is done, uh, how you have come to that proper value, you should have a proper valuation report, and the methods used or whether the proper standards are being used or not, that should be clearly documented. Next is to avoid treating the ARC as a promotional vehicle for purchasing the assets from related parties at inflated values. Ensure the ARC is buying at market price and the SRs reflect the fair value. So again, this point is to be taken care by the ARCs themselves. And we being the insolvency professional, we should also, we can also probe into that scenario wherein if ARCs are used as a promotional vehicle, then we should try and avoid such ARCs to come into the IBC regime. Then next is documentation and audit trail. Maintain detailed documentation, board minutes approving the acquisition, third-party legal audit opinions as no circularities there, confirmation that seller is a bank or financial institution, proof of consideration, borrower notice of assignment, independent valuation, regular internal audits of patterns of acquisition for any signs of evergreening or reuse of the assets just to hide the default. So how can ARC make sure that, or how it can prove that it has not entered into any kind of this evergreening thing? So he can simply show that we are doing regular internal audits wherein everything is checked, everything is made sure of, and even being an insolvency professional, we can seek the internal audit report specifically mentioning that there is no sign of evergreening. So we can even ask this kind of thing. Regulatory interactions and transparency. Just a second. Yeah. Have an early engagement with RBI or registrar if required when acquisitions are large or from the connected entities. Just to be on a safer side, it is mentioned that whenever high stakes are involved, you should also always try to get you should always try to get these regulators also in picture. They should also know that something is happening, and you should seek guidance from them as well at times. Maintain transparent disclosures in an annual report. Investor communications that acquisitions are arm length, no circular funding, and valuations have been independently arrived at. So again and again, it is very crucial on the part of ARC to make sure and to disclose that everything is being done in a transparent fashion. There is nothing to hide or deceive, or it is not a fraudulent case, something like that. So they have to make that thing very much clear. Now, what is the exit strategy and monitoring? That is also to be documented very specifically. Post acquisition, monitor the borrower's repayment, any fresh exposure to the same borrower or promoter, and the rights to the ARC to enforce security under the SARFAC or via IBC. That should be properly documented. Then, if fresh lending occurs to the borrower by the same group or entity, assess whether that creates a risk of regulatory scrutiny for evergreening. So, what is the summary for this particular challenge is for the ARCs particularly and the IPs who may review them, they have to ensure that the acquisitions are clean, arm length, well documented, independent from promoters, related parties, and free from layering of fresh funds solely to enable repayment of the old loans. So it is not just that, it's not a there could be malified intentions also. So again, that buffet transaction which we have to seek, which we have to make opinion of, it can lie in this kind of scenario. So we have to make sure that everything is well documented, everything is well it is at arm's length, and this is something which we have to make sure. And in the event of regulatory action, as in the case of Edelweiss, the ARC's portfolio valuation and assignment chain will come under the scrutiny. So that was done in that particular case. Next challenge for ARCs or IPs would be with respect to the valuation disputes in CIRP. So registration of valuations, use of registered valuer, confidentiality, and fairness could be the key areas where we have to actually drill down, and we have to be very cautious about. So under IBC and CIRP regulations, the RP must appoint two registered valuers. This we all understand, and here in the case of ARC, it is very, very important to have that kind of scenario from the very beginning, that you have two registered valuers, and they are there to determine the fair value and the liquidation value both. Regulation 35(1)A states two registered valuers shall submit estimates in accordance with the internationally accepted valuation standards. Regulation 35(1)B provides that if the two estimates are significantly different, that is, if the difference of 25% or more under a given asset class, then the RP may appoint a third registered valuer, and the average of the two, this is something we all understand. So how this valuation should be done, when it should be done, then a new valuer is required to be appointed. So all that we understand, so we have to follow the provisions as they are there. So valuation disputes frequently arise, for example, in case of divergent valuers, challenged by dissenting creditors, delays in appointing valuers, confidentiality breaches, etc. So this obviously delays the whole process of CIRP. So we should try and mitigate these kind of practices wherein there is any kind of valuation disputes. So it is very important for an IP to maintain clarity about the valuation aspects. Who can be appointed as a valuer? Only the registered valuer should be appointed as a valuer. Minimum, I mean, two independent valuers should be there, and for each class you can have separate valuers. That is very, very important. And again, I mentioned it earlier also, the liability is on the insolvency professional only. You cannot say that the valuation was done by some expert. Again, you have to check it. You have to make sure that every asset was considered, and proper valuation method is being used, proper standards are being followed. Because ARC may hold claims both on plans or themselves act as a resolution applicant. They have a major stake in the valuation outcomes. IPs must manage process strictly to avoid challenge of commercial wisdom by COC or approval being set aside. So this is something which they should take care of. How to mitigate this challenge? Early appointment of registered valuers is very important. So IP should appoint 2 registered valuers under the regulation 27 within the timeline, and the timeline is within 47 days from commencement to 47 days they have to do that, and ensure they are independent. ARC, if participating or bidding, should review the valuation process and request the access via COC to the valuer's scope, credentials, methodology. And nowadays, in COC meetings, you can have the valuers, you can invite them also, and they can disclose the methods adopted by them so that later on there is no confusion. So at the beginning itself, you can have their meeting. Next, clear scope and asset class segmentation can be done. Then manage the divergence, and third, valuer process. This is something which we all understand. Then confidentiality and control of information should be there so that important informations are not leaked out anywhere, and the proper confidentiality undertaking should be taken. So IP must secure the valuation reports, strict viewership, and ensure valuers' work papers are preserved and secure. Okay, what is the summary of this challenge? We can read out from here. For ARCs and IPs, valuation process under IBC must be rigorous, timed, independent, confidential, and documented. So everything, what methods have been used, which assets have been taken into consideration. Okay, tangible as well as intangible, both are to be considered. It is not just that only tangible assets are considered, and whether they are in India or outside India, wherever they are, everything has to be taken into consideration. So at the time of getting the report from valuation valuer, as an IP, you must make sure that everything has been taken on record. So that is your responsibility ultimately. And again, it should be a very confidential document. Given the link between valuation and claims, bidding, COC, voting, and recovery, weak valuations can result in dispute, challenge, or loss of value. We all understand if the valuation, if it results into undervaluation, it will not be good. And again, if it is overvaluation, it will not get good resolution plan. So valuation is the key. Actually, we must have proper valuation and in time also. Next could be, one more challenge which this ARC could face here is with respect to the secured creditor relinquishment versus claim in the liquidation. So where should they, which position should they take up? Whether they should relinquish their claim or they should participate in the liquidation, how they should do. So under the IBC, when a corporate debtor goes into liquidation, the waterfall of claims and the rights is specified in under section 53. We all understand that. So on one hand, it allows you to relinquish the security interest and opt to claim in the liquidation estate. And on the other hand, it says that it allows the secured creditor to enforce the security interest outside the liquidation process. So sometimes it becomes confusing which one to be taken up, but that is ultimately their decision. So that what we are understanding here is a challenge which is faced by ARC at times. So this could be one of the challenges to them. So how to mitigate this challenge? First is to evaluate the security value and net realizable value. So by properly checking the difference in the values, you can clearly come up with the solution what is to be done. So if the security value is high and enforceable quickly, then obviously enforcing may give higher recovery and earlier cash flow. If the asset is difficult to enforce or low value, relinquishment may make sense. So again, if they have some kind of confusion, you can always tell them that they can seek a legal opinion. Then next is check procedural prerequisites for the enforcement. Ensure the assignment or the charge is properly perfected. Asset security interest is valid. Any SARFAESI enforcement notices have been issued and no stay exists from the court. If doing enforcement outside the liquidation, ARC must confirm that the sale proceeds will not be eaten up by the cost challenge or the third party claims. Again, the timing of relinquishment decision matters. Then understanding the ranking and recoveries under section 53, that also matters. Then how you coordinate with IP or liquidator. ARC should liaise with the liquidator or RP to monitor the liquidation estate, verify the asset realization cost, and ensure the claim file is properly captured, documented, and included. So here, we can have one more role besides being the resolution professional. Here, we can even go for the consultancy work if we are going. So if we are consulting any, giving a consultancy service to any ARC, at this point of time, we can, give the consultancy which point is better for you. Which side is better for you to opt. So that way also you can take up these points. So document decision, audit trail, and internal approval, all this is okay. So summary of this particular challenge is ARC and IPs must strategically decide whether a secured creditor should enforce its security or relinquish to participate in the liquidation distribution. The decision affects the recovery, we all understand that, and the quantum, timing, ranking, and all obviously is important. Poor decisions or lack of documentation can reduce the recoveries or lead to disputes. So our ultimate aim is to, have win-win situation for all. So if these kind of challenges are there and ARCs is facing these kind of challenges, how we can help them to mitigate these challenges, and how we can smoothen the process. That was the whole idea to discuss this particular aspect. So still, if we have any doubts, you can ask, or otherwise there are some FAQs which we can discuss. So let me quickly share the FAQs in, if there are no doubts. I hope my screen is visible. So this will be a kind of revision, whatever we have studied. Some questions you will find that, oh, it is very simple, but it will be a quick, revision for all of us. So what distinguishes an ARC's role under SARFACI from its role under IBC? So the answer also I have mentioned here. Under SARFACI, ARCs act as creditors and they enforce the security interest. Individual asset recovery mechanism is what they take into consideration. Under IBC, they act as financial creditors or resolution applicants. So here they use collective value maximization kind of thing, and even they can go for uh, 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 continuation, going as a going concern also, they may take it up. Then this was particularly discussed in this case for a India Limited versus Edelweiss ARC. Here it was held that ARCs have locus to initiate CIRP as financial creditors as well. So if you want a particular case law wherein it was mentioned that whether this ARCs can act as a financial creditors. Yes, they can act as a financial creditors. They can file an application as a financial creditor. This was mentioned in this particular case. So next question is, can an ARC initiate CIRP against a borrower under Section 7 IBC? Of course, yes. Once a financial asset is legally assigned to ARC, it becomes financial creditor under Section 5(7), and he can file for CIRP application. And this was also discussed in this particular case, Phoenix ARC Private Limited versus Ketul Bhai Patel. So they can file Section 7 application, and now it is, clear by the circular also, master circular. If they fulfill the conditions, they can. Okay, that was with respect to the resolution applicant. This is regarding filing of the Section 7 application. So Section 7 application can be filed once you are categorized as financial creditor and there is a financial debt, obviously, and there is a default. So that is a different aspect. Third question. Are ARCs eligible to act as resolution applicant? yes, the circular number we must remember. RBI circular is dated 12th October 2022, specifically mentioned that ARCs with net owned fund greater than or equal to, that is minimum they should have 1000 crore. They can submit plans under IBC. The condition, other conditions also have to be fulfilled. They must have a board approved policy. They have to comply with section 29A of the IBC and dilute control within 5 years post plan approval. That is very, very important. Next question is, can an ARC act both as a COC member and as a resolution applicant in the same case? So only with strict safeguards, the ARC must disclose conflict of interest, recused from voting on its own plan, and follow RBI's conflict management policy. However, the best practices, separate internal teams for credit and resolution bidding function should be there. Next, what happens if an ARC purchases a loan from a related party, a financial creditor? So it may still be qualified from COC, it may still be disqualified from COC voting if the assignment appears designed to circumvent related party exclusion under section 21 to proviso. So this was held in Phoenix ARC Private Limited. Here it was held that mere assignment does not cure related party claim. So again, you have to do the thorough checking whether it is a related party, it comes into that picture, then obviously it will be disqualified from voting. Next, what due diligence documents must an IP verify for an ARC claiming creditor status? I think this we all know, but let us quickly go through. Assignment deed, it should be properly stamped and registered. Notice of assignment served on borrower. Proof of consideration paid. Bank statement of the ledger or bank statement of the ledger of the assigner, and the updated CERSAI ROC filings. So this also you can check CERSAI filings or the ROC filings, which can be taken up as an evidence that proper recording is done. Can an ARC enforcement under SARFACI continue under CIRP admission? The answer is no. Section 14 IBC impose a moratorium on actions against the corporate debtors asset. However, SARFACI can continue against the guarantors or the third party collateral, but not which are not owned by the corporate debtor. So this is very important, and this was given in the case State Bank of India versus Ramakrishnan. So obviously this is something we must understand, that once moratorium applies, the all other litigations will come to standstill. How is an ARC's voting share in the COC determined? So by the admitted debt amount at insolvency commencement date, including the interest up to that date. The assignment price or the SR face value is irrelevant. So this is again very important. The assignment price or the SR face value is irrelevant. What we have to check is the admitted debt, admitted debt amount, including the interest up to that date. So IP should maintain a clear COC voting share register, proper, how you have computed that, how you have reached to that particular voting share, you have to keep your records, your calculations with you. Next, can ARC participate in liquidation auctions under IBC? So the answer is yes, subject to the eligibility under section 29A, we already know that, and liquidation regulations also 32-33. And this was discussed in Edelweiss ARC case also. They successfully acquired assets during the liquidation auctions. Next, how do valuation principles differ when ARCs are the bidders? So ARCs often use distressed adjusted recovery models, while IP use this particular ICAI IVSB 126 standards for fair and liquidation value. So valuation standards are altogether different if we talk about IBC. So therefore, the rule is the RP valuation always prevail for the COC decisions. ARC valuations may guide bidding but not replace the independent values. Next question is, can ARC promoted AIF or trust invest in resolution plan? So what is the answer? Can an ARC promoted AIF or trust invest in a resolution plan? Well, the answer is yes, if permitted under the RBI directions 2024. There was a proper circular issued that time also, and ARC's board policy. Uh, the ARC must ensure arm's length structure and no violation of Section 29A. Again, everything has to be documented, it has to be proved. Then next is, how does an ARC status affect liquidation waterfall? So again, we understand that he has both the things, both the rights. He may even relinquish the security on one hand, or he may keep that outside the liquidation. So that is his call, how he takes it up. So dual recovery is obviously not allowed. He must elect any one of the routes. Next question is, what are RBI's capital and governance threshold for ARC? So this is something, if you want to check the status of the ARC on records, whether it is actually complying with all the regulations of RBI. So that is what you need to check. Minimum net owned fund, they should have rupees 300 crore by March 2026. Independent directors on board, they should have they are supposed to have more than equal to or more than 50%. If sponsor share, then more than or equal to 50%. So this part, I mean, you can take it up in detail also later on, because the circular is properly there, and details are mentioned how this has to be computed. So for the independent directors also, there is a percentage which you have to maintain. Then audit and risk committees are mandatory. We have already seen that. Next, can an ARC purchase stressed asset during a CIRP? So only through the transparent COC approved process, direct bilateral purchase is barred during moratorium. Post liquidation, it can buy through the auction. So that is the, I mean, probable solution. It can be there, but again, you can always seek guidance from NCLT or anywhere. If you want to seek any legal opinion, you can go for it. Next, are ARCs treated as financial creditors even when they hold only SRs? So if SRs represent underlying assigned debt and ARC is the SR trustee with control rights only, then in that case, the answer is yes. If ARCs are only the managers of the security receipts for the investors without any ownership, the standing may be questioned, because again, the ownership of the debt is very important. So if you are owning the debt, then only you will be considered as the financial creditors. Next, can ARC own debt instruments be used as consideration in the resolution plan? So the answer is no. Payment under IBC must be in cash or securities issued by the successful resolution applicant or the corporate debtor and not the third party. So I think that's it for it. I mean, if there are many more questions, but I think we can see some case study. So here there is a case study kind of question. ARC um, dissented from COC approved plan claiming higher payout. So Supreme Court upheld the COC's commercial wisdom here, clarifying that ARCs, though sophisticated, are bound by the collective decision. And this was dealt in this India Resurgence ARC versus Amit Metalinks Limited. So here the takeaway for us is IPs must record COC decision carefully, why they have come to this conclusion, what was the, I mean, reasoning behind it. That is to be, properly documented to defend against any kind of dissenting ARC challenges. Next case is with respect to ACRE, ARC and SL group debt. Here, ACRE, ARC acquired rupees 1,350 crores SL group debt and 2,613 crores SME portfolio, becoming lead bidder for the several assets. So here ultimately what happened is they can acquire these two things also. So ARCs now act as consolidators and strategic bidders both, but IPs must coordinate on valuation transparency and COC disclosures. So if they are coming into dual role or double role, so IP has to be very much cautious, proper steps have to be taken, and disclosure is very, very important. Next, Phoenix case we have already discussed, but again, let us see it here. Phoenix ARC continued enforcement on guarantor property while CIRP was going on against corporate debtor. So, okay, this is something different. Tribunal upheld enforcement since asset was not CD's own. So, clarifying SARFAESI IBC interplay. So, IPs must clearly delineate debtor versus guarantor assets under moratorium. So, if CIRP is going on the corporate debtor, guarantor's property is different, obviously. So Phoenix continued enforcement on guarantor's property while CIRP was going on the corporate debtor. So tribunal has upheld this kind of thing uh, since it could be done in that way. Next, there's one more case last. ARC Lemicraft plan approved. In this case, what had happened? NCLT approved the resolution plan submitted by ARC Lemicraft Private Limited, validating the ARC's eligibility and compliance with the RBI circular. We don't have all the facts, so we cannot check that out. But we can just see the takeaway. What is it? Proves that ARCs are now accepted as the mainstream resolution applicant under IBC. So this is the case. I mean, this is a recent case, 2024 case only. You can check that out. So here, I mean, resolution applicants' role is being taken by the ARCs, and that is something which we must be clear of. That nowadays they can also come into the position of resolution applicant. So they have both the doors open for them. They can, I mean, for ARCs, they can even go for SARFAESI or they can come for the IBC, whatever they want to. So, any feedback, any questions from anyone? We still have 5-10 minutes to go. Okay, there is a question in the chat box. I'm just reading that out. Possession taken under SARFAESI, say on completion of 2 years by the bank, then the bank assigned the loan to ARC. Okay. If ARC files petition after 1 year, that is in total 3 years crossed under section 7 of IBC, whether the application is valid. So you're talking about the limitations, sir? Here, you can unmute and you can speak it up, sir. Rajgopal, sir.
Yes, your question is correct.
Yes.
Limitation only I am asking.
Yes, sir. So you are yourself saying, sir, it is within 3 years. 3 years have been crossed, but again, sir, the other documents also we must check whether there was any extension, whether the liability was there in the books of the corporate debtor. That part also we can check. We have seen it in one of the examples.
Okay.
So that will also hold as a proper, I mean, valid record that it will acknowledge for the debt.
If there is no acknowledgement means, then
Again, we have to prove that on our part. So
Okay.
that is it. It will be difficult to prove in that case, obviously.
okay.
Yes.
Thank you.
Okay. So if there is no more question, we can wind up the session. Thank you all for the patient hearing. This topic was actually different one. I would say for the ARCs, if they can be taken up as a resolution applicant, we have to be more cautious. And in any case, I mean, they have both the doors open nowadays. So that is it.
Thank you, madam. Thanks a lot.
Thank you.
Thank you. Thank you. Thank you so much. So I think it's a lunch break time. Anjali? Yeah.
Thank you very much, ma'am, for giving your valuable time and share your experience on the topic. Thank you very much, ma'am.
Thank
Ma'am,
you.
you are
Thank you.
requested to please share your PPT of the
So
session.
I'll do that. I'll do
Thank
that.
you,
Yeah.
ma'am.
Thank you.
Now,
Thank you.
this lunch break till 2 p.m. Next session will start at 2 p.m.
So happy learning to all of you. Bye. Bye from my side.
Thank you, Divya. अभी 2 PM को बोल रहे हैं नेक्स्ट सेशन.
Okay. Okay, sir. Thank you.